In episode 28 of the Borman Lawyers Court Reports show, we take a look at a drug possession matter of 8 MDMA capsules where we achieved a Section 10 dismissal of the matter.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. They say it ain't no way. I ain't never listened, kept them at the distance. This is for the ones who ain't afraid. And this is more than some paper chase. I wonder who else can say the same.
G'day guys, it's Josh Borman here. I'm coming to you from Manly Wharf, a little bit of a different location to how I usually film outside the courthouse, but I have just attended the Manly local court this morning where I appeared on a drug offence matter. It was a plea of guilty to possession of a prohibited drug, namely MDMA. The client was attending the Greenwood Hotel on a Sunday afternoon, which is quite a well-known spot for dance parties and drug-taking activity. He had been there since midday, drinking quite heavily, and then at around 5:30 p.m. he was approached by another fellow who was actually selling ecstasy at the event. My client was somewhat intoxicated under the influence of alcohol and failed to use his better judgment by accepting to buy some drugs, some ecstasy off the seller. Now, my client said to the seller that he only had a little under $200, so he would buy whatever that amount got him. He went into the toilets with the seller, came out a few moments later, and was witnessed the whole time by undercover police, who quickly took up with him and began to question him. Immediately, my client fessed up, owned up to having ecstasy on him and the fact that he just purchased it. He did have 8 MDMA capsules, and that was a total weight of 1.1 grams. So he was quite lucky in the sense that he was charged with an offence of possession as opposed to an offence of deemed supply. Once the amount goes over 0.075 of a gram of MDMA, it's up to the discretion and based on the facts of the police prosecution whether they want to elevate the offence from a possession charge to a deemed supply charge, which is a lot more serious. However, it stayed as a possession offence, thankfully for my client. There was no indication or evidence there that he was going to supply or give the drugs to anyone else. It was solely for his own personal use, despite the fact there was 8 capsules there. So it wasn't just 1 or 2 capsules, there was quite a large amount of capsules there, and as mentioned, he fessed up, owned up, immediately remorseful with police, and pled guilty to the charge of possession of MDMA capsules. In the lead up to this matter, we arranged for some very good and well-written references from my client's employer, another friend of his, and also we got him to write up a letter of apology to the court, detailing a bit of background about himself, some issues that he'd been going through, and how incredibly foolish and sorry he was to put himself in such a risky position. He also mentioned that he had since learned the devastating and serious health side effects that taking illicit drugs can have on people, and that was well received by the court. So we presented the matter here today at Manly local court. It was touch and go whether our client would receive a conviction or not. We were certainly seeking for a Section 10 no conviction, but due to the fact that there were 8 MDMA capsules, it was certainly within range for our client to be convicted and potentially receive some community service or at least a good behaviour bond and a substantial fine. Luckily enough though, our matter was well received. The fact that our client had no criminal history here. He was originally from the UK, he's been here for a couple of years working full-time and has plans to travel overseas in the future. We did submit that a criminal conviction could certainly cause problems with him gaining entry into other countries, especially for drug-related offences, which carries a certain type of stigma around the world, and especially when trying to gain visas and entry to other countries. So we did indicate to the court that a criminal conviction could cause significant repercussions for our client going forward. But no criminal record here. We were able to obtain a copy of his UK record, which there was nothing there as well, and it just showed that this was a one-off aberration of our client, who would usually conduct himself in a a far more diligent and law-abiding way. So it was a very out-of-character situation for him to be involved in, and it wasn't a matter where he went looking for the drugs or sourcing the drugs out. It was a very spur of the moment, unplanned, spontaneous, rash decision that he made to purchase these drugs when he was actually approached by the seller who was selling the MDMA capsules. So he certainly made a impulsive and very foolish decision to buy these drugs. Within minutes he was taken up by police, and that's how he landed himself before the court. So the references and the letter of apology was very well received. So were our submissions in asking the court to not record a criminal conviction. He was given a section 10(1)(b) and put on a good behaviour bond for 12 months, which means that he needs to be of good behaviour for 12 months. If he breaks the law and appears before the court again within that period, then he will be resentenced on the matter today, as well as any fresh charges which he's been charged with. So very, very happy and relieved client today, and we were chuffed to get such a great result with quite a large amount of MDMA tablets in our client's possession. So if you've been charged with any sort of criminal offence in New South Wales or even Queensland where you appear, feel free to give me a call on 1300 941 900. Alternatively, you can go along to our website, which is Boorman Lawyers, BOORMAN lawyers.com.au. There's plenty of information there on what we do, laws, penalties, offences, blog posts, videos like this, statistics, and you can read up a bit about the situation you might find yourself in. But of course, feel free to give me a call, 1300 941 900, to discuss your matter further and see how we can best represent you when your matter comes to court. Thanks for tuning in today, guys. Thanks.